majority black districts, again, in advance of the 2024 congressional election. So while we were preparing for a remedial hearing so the court could hear from all the parties and see various maps that complied with this law, the legislature in January took it upon themselves to pass a map with 2 majority black districts. While the map that they passed did not look similar to the maps that LDF offered, it complied with the Voting Rights Act. It had 2 majority black districts, and that was signed into law by the governor in January. So celebrating that was very short because about a week after, a group of plaintiffs filed a lawsuit alleging that this new map was a racial gerrymander. So that's the case that we're talking about now, which is, like you stated, LA versus Landry.
And Sarah, I don't know.
Apologies.
And Sarah, I don't know if they ever identified who those plaintiffs were or what their race were. Yes,
so they actually
who are they?
Identified. They are a group of individual plaintiffs that have identified themselves as, quote, non-African American voters. Exactly. So while none of the plaintiffs appeared in court, that's how they've been described in their litigation.
Wait a minute, Sarah. Did you say that none of the plaintiffs appeared in court?
They did not. Not in the Calais versus Landry hearing.
So then to this day, we have no idea who these plaintiffs are that have said that they are, other than non-African American, that say that they've been discriminated against, I guess really reverse discrimination is what they're sort of claiming. Is that right?
Yes, the racial gerrymandering claim is based on discrimination on the basis of race.
Wait a minute.
And a violation of their dignity.
Is that right?
Yeah.
Wait a minute. I mean, where did they get standing? Sarah?
So that's a great question.
How did the court grant standing in this case?
So that was not explicitly addressed. In the district court's opinion, Judge Stewart, in his dissent, did make note of that. And in addition to that, he did make note of the fact that many of these plaintiffs do not actually live in the challenged district, for one of the plaintiffs. So that was not something that necessarily was established at the lower court, but it also was not necessarily challenged.
Oh, come on. And I understand that this was a very hard case for everybody listening. We want you to know, we don't expect everyone to be lawyers. And so when we use terms like standing, that's a legal requirement. In order to get into a court, you got to show that you were directly injured by a practice or policy or action of someone who's covered by the law, especially where you're alleging state action, that the state itself engaged in some kind of illegal activity under the 14th Amendment. And so it's really odd to have a case in this posture, as we would call it, where there's, a couple of named, plaintiffs allegedly who are identifying themselves as non-African American, but who have not even established injury, direct injury, because some of them don't live in the district that's under consideration. So how are they injured? And also where we don't have them certified as a class, that they somehow represent enough people. I can go out here and be mad about the way the streets look, in my neighborhood, but do I represent all the people in my neighborhood? I got to establish somehow, if I'm going to bring any kind of substantial action in court, that that's what has happened, that I represent more than myself. Well, this is a problem. I mean, just coming off the bat, as you're describing this, Sarah, and Dr. Robinson, this is a huge problem. And I also understand from the case papers that this court, it was a 3-judge court, 2 decided the wrong way, 1 dissented. But I also understood that during this entire proceeding, this quick proceeding of this alleged non-citizens, black citizens people, that they wouldn't even allow full intervention. Is that correct? By the parties
Yes.
that had brought the original case?
Yes, thank you so much for highlighting that, because this is one of the most significant things of this.
Right.
While I said it was brought in January, it was decided about 2 months following. So at first, we weren't allowed to intervene in the case. We had to the judges denied our original motion for intervention, said we could intervene at the remedial phase if that happened. And we had to move the judges to reconsider. And that was upon showing how little effort the state was actually making to defend the map that the legislature enacted. And then while we were still not...
Wait a minute. Daryl, did you hear that? Did you hear that? Collusion. The state was putting in very little effort to defend the map. Oh, my goodness. Okay, go ahead, Sarah.
Yes, so they granted the reconsideration after seeing the original briefing. So that's when they permitted us to intervene. And then while we were still, our reconsideration was pending, the judges consolidated the preliminary injunction with the trial on the merits, meaning that any decision that would come out would be a final judgment.
Wow. So when you were saying that these issues weren't raised, part of that's because you weren't in the case.
Exactly. Exactly.
I get it. Oh, my goodness.
And
this is horrific.
We had yes. Go ahead. Sorry.
Yeah. Sarah, I think a bit of a more practical question from me, just so that our audience is clear. So in this case, we have the Louisiana legislature, unlike Alabama's legislatures that thumbed their nose about creating the new black districts, that they weren't going to do it. Louisiana's legislature said, okay, courts, we've heard you. We're creating the second majority black district. They do that. Is that correct?
That's exactly correct. After exhausting all legal avenues, which the Attorney General stated. Exactly.
Okay. Right. And so after they've now created this second district, Dr. Robinson, and this is so that they can have an additional black member of Congress, really, that's able to vote. Now it's voting time in Louisiana. The primary is here. Can they vote for this new black person that the courts have said need to be in place? This new
absolutely not.
District?
No.
Not in November. Of course not. We cannot. As a matter of fact, we don't know what's going to happen in November, whether there will be an election or not. And if so, will it be on the basis of the 2021 map with one district? Will it be on the map that the legislature had? Or will there be maybe a delay in the election? So we're not sure what's going to happen.
And since this horrible ruling by these two, judges in this case of the Calise versus Landry case, can you tell us what has happened? Because LDF and the plaintiffs have not sat back quietly. Tell people listening what you've done to challenge this horrifically wrong decision.
So LDF, as well as the state, have filed for an emergency stay in the Supreme Court. We're asking the court to stay this decision and keep the current map that the legislature passed in place for the 2024 election while this appeal to the Supreme Court is ongoing. So at this current moment, we received the plaintiff's responses yesterday. We're awaiting an order from the Supreme Court, and we actually have a remedial briefing due on Friday because the court has stated that if the legislature, the three-judge panel, like you said, if the legislature doesn't enact a map by June 4th, that's the time that the court itself is going to select a map. And there's also a lot of issues there because there are a lot of legislative rules and other things that are going into play that make it so that the legislature really cannot bring a bill and decide a map in that time period. So just emphasizing again how quickly this has all been rammed through, I want to just go back and state that this was a 3-day hearing. And just for comparison, and this was a trial on the merits, in our state legislative case, Nairn versus Arnwine, we had 7 days, 20 witnesses, 258 exhibits. In Robinson, the congressional case, we had a 5-day preliminary hearing. Again, 20 witnesses, 231 exhibits, and a 165-page opinion. And here we had 3 days. We had a 60-page opinion, and now we have a remedial hearing scheduled for May 30th, where there's not even going to be any additional evidence presented. All the evidence we're allowed to present is going to be this Friday in our briefing. Nothing in person at that hearing. It's not an evidentiary hearing. It's a 1-day remedial, effectively oral argument.
Wow.
Can I throw a fly in the ointment here?
Oh, please.
Throw a bunch of them in there, Dr. Robinson.
Let us assume that the legislature passed its bill with 2 majority black districts with the clear intent that what happened in western Louisiana would happen. That is, there would be a group of people who would file suit and that we would have a judge throw this out, which means that there's a great possibility that we might revert back to the 2021 map with one single majority district. Everybody's happy except us.
And
I'm not saying that was the goal, but it could have been.
Well,
it sounds orchestrated.
Absolutely, Barbara. Dr. Robinson, in listening to this and what's going on right now in 2024 in Louisiana, it just sort of takes us back. And I know that, could you share with our audience your experience when you went to just to register to vote and what you experienced when you were going through the voter registration process itself? It almost seems like it's a continuum from what you went through then to where we are now. Dr. Robinson.
Exactly. The more things change, the more they stay the same. And when I was a young man at 21, I went to register in South Carolina, which is my home state. I'm a transplant to Louisiana. But I was told then by the clerk I had to read and interpret the United States Constitution. Well, I was a college student. That wasn't a problem for me. So when I started to read, after I read the first line, she said, "Fine, stop. That's okay." And she said, "Sign right here." But there were other people who went to register who had to count the number of jelly beans in a jar, who had to pay a poll tax, or other kinds of obstacles to keep us from registering. That was the first time that my mother ever had the chance to even to register to vote, because I took her with me, and I insisted that day that she register, and she was allowed to do so. My dad registered at some point later. But what's happening in this country today, especially among the Republicans, is to move back everything that we have gained. The Voting Rights Act itself has been attacked on more than one occasion. And if we're not careful, the Eighth Circuit Court of Appeals has already attacked the last part of the Voting Rights Act.
Oh, yes. And
okay?
Dr. Robinson, you should know, you may not know it, that the Transformative Justice Coalition has a whole huge alliance of organizations and people who have been working on the Eighth Circuit decision. We have done a number of shows about the Eighth Circuit case, the NAACP, the Arkansas NAACP case. And we have talked about what happens if what these MAGA, and that's what I call them, MAGA, neo-Confederate, white supremacists, state attorney generals have their way, because they've actually asked in the Georgia case for not only for private people like yourself and the LDF not to be able to bring these kind of cases, not to be able to safeguard our rights. But they also have asked that the entirety of Section 2 of the Voting Rights Act be declared unconstitutional.